Go. Thanks everyone for joining us today. I'm excited to be in Jackson, Mississippi, and excited to be up here with these great panelists. My name is Conor Norris. I'm a research analyst at the Knee Center for the Study of Occupational Regulation at St. Francis University. And I'm also a policy fellow with Empower Mississippi. My research area focuses on occupational licensing, healthcare scope of practice laws, and general access to healthcare. At the Knee Center, we focus specifically on occupational licensing, and we do a few things in that space. The first thing we do is provide state and policymakers at states with information about the scale and scope of occupational licensing within their states and what's going on in other states so they can measure against them. We also do academic literature, so we will publish in scholarly journals, research, again, focusing on occupational licensing. We'll do other reports for states, like much smaller, simpler reports, and for state think tanks. We'll write op-eds in the popular press. And finally, we are compiling and maintaining a database on occupational licensing for professions in all 50 states. That's free and publicly available on our website, where you can go and see what professions are licensed, what the licensing requirements are, and how those compare to other states for the same profession. Now, regulations are designed with the best of intentions. Policymakers find a problem, they try to work towards a solution. But often these regulations have unintended consequences, sometimes small, but sometimes these costs can be quite large. And over time, as we implement more and more regulations, they tend to build up, and we see these costs grow larger and larger. Now, of course, we have this cost on GDP or employment numbers, and as economists, that's something we worry about, but this also affects real people, our neighbors, people in our community that are suffering, they're struggling because of this regulatory accumulation. The example I like to give is one of my personal friends was a combat medic for 2 tours in Iraq. He came back and he wanted to become a nurse, keep using that healthcare experience that he had. Unfortunately, in the Commonwealth of Pennsylvania, they did not accept any of his previous military training and experience towards getting that nursing license. So he had to go back to school and start from stage 1, re-enroll as a freshman. After 1 semester, he figured it wasn't worth the time and the money he was going to have to lay out for it, so he ended up going back into the military. A lot of people don't have that kind of backup plan that he had, and they're stuck either unemployed or working in professions that are lower paying than the profession they'd like to go into and less fulfilling. And that's something I think we need to remember, that the barriers posed by occupational licensing isn't just affecting these overall statistics. What they're affecting is real people. So in our panel this afternoon, we're going to discuss overregulation, how this accumulation builds up over time, some of the things we can do about it, some of the reforms that are necessary, and some of the reforms that Mississippi has been implementing the past couple years. So public policy is important, and we should strive to do it as well as possible. And when there are problems with it, we should be willing to reassess it, see what's going wrong, what's going right, and think of a better way to move forward. And again, Mississippi has been doing that over the past couple years, so it's really exciting to be here talking about this. Because not only does it make the state economy better, but it helps people live better lives. So joining me to talk about this are 2 great panelists that just because I'm sitting up here next to them makes me look even better. Our first and probably the best musician on stage today is James Broughel. He's a senior research fellow at the Mercatus Center at George Mason University and an adjunct professor of law at the Antonin Scalia Law School. James specializes in regulatory institutions, cost-benefit analyses, and the impact of regulations on economic growth. He's authored the book, Regulation and Economic Growth, Applying Economic Theory to Public Policy. And his writing has appeared in popular outlets like the Wall Street Journal, the LA Times, and the Washington Post, and he's a regular contributor to The Hill. He's published in scholarly journals, and these include Regulation and Governance, Contemporary Economic Policy, and the Harvard Journal of Law and Public Policy Federalist Edition. He received his PhD in economics from George Mason University and his BA and MA in economics from Hunter College, the City University in New York. Thanks for joining us, James.
Thank you. It's great to be here.
And next we have Whitney Lipscomb, a rock star in her own right, and who many of you guys already know. She's the Deputy Attorney General for the state of Mississippi, and prior to this, she served as a Deputy Chief of Staff and Counsel for Governor Phil Bryant. In this role, Whitney provided strategic counsel to the governor on a wide range of policy and legal matters. Whitney previously practiced law in Gulfport, where she did civil defense work and regularly represented state entities. She earned her Juris Doctors from the University of Mississippi School of Law and her bachelor's degree from Mississippi State University. Whitney, thanks for joining us.
Go Dogs. Thanks, Connor.
So first, I'll start with James. In policy circles, you're known as one of the leading scholars on regulatory impact and reform. But for those outside of those circles who may not read regulatory impact analyses for fun, will you talk to us a little bit about what the Mercatus Center is, what's Mercatus's guiding philosophy, and talk about the kind of work that you do there?
Sure. So first of all, thanks, Connor, and thanks to everyone at Empower Mississippi. Can you hear me okay? Good? Okay, good. So Mercatus Center, which is where I work, is a university-based research center based out of Arlington, Virginia, on the campus of the law school at George Mason University. So we kind of straddle the divide between the academic world, which is kind of engaged in high theory, and the policy or think tank world, which is engaged in more practical solutions. And we try to bridge that gap and take those ideas out of the academy and make them actionable in the real world. So Mercatus funds a lot of graduate students, mostly economics students at George Mason, but also students at other universities and studying other topics. And then we also have a lot of researchers engaged in producing policy-relevant research, like myself. My area is regulations, and I've spent the last few years focused on state-level regulations in particular. We built a data set at the Mercatus Center. We call it State Reg Data, and it builds on a previous project that we had at the federal level, which was just our Reg Data project. And what we're doing is we're applying modern technology to analyzing regulations. So most administrative rules or codes that states have or countries have are too large to read through from start to finish. So if you're a researcher of regulation, you don't really have time to just sit down and spend months or even years reading all these rules. So we need technology to make sense of them. And so we've been using computer programs to try to parse legal text in particular and make sense of all these rules and better understand what's in them, how much regulation is there, how do different states compare to one another, which industries are the most targeted by different rules or requirements. And so the first iteration of our state data set came out in 2019. We found that the average state has about 9 million words of regulations in its administrative rules. And that's just in the administrative code. So these are the laws that the various executive departments write and produce. So the Department of Health, the Department of Natural Resources or Environment. We're not looking at the laws that the legislatures pass or all the various informal kind of regulatory activity you might find at agencies, like different notices that they write. So just in the administrative rules. The average state has about 135,000 restrictive terms in its rules. So terms like shall, must, or required, which are a proxy you can use for the number of regulatory requirements in place. Mississippi has about 116,000, so it's a little less regulated than the average state. But more than a state like Idaho that has just 40,000 regulatory restrictions in its rules. On the other extreme, we have California that has 400,000, or the federal government that has about 1.1 million restrictive terms in the Code of Federal Regulations. So there's a lot of variation across states, and there's a lot of variation across the states versus the federal government as well. So with these data, we're starting to better understand some of the effects of regulation. Already the state data set I'm talking about has been used in a couple peer-reviewed academic studies, and our federal data set has been used in, I don't know, maybe 20 or so peer-reviewed academic studies. So the data is starting to help us better understand what causes some places to have more regulation than others, and what's the effect of all this regulation.
Thank you. And I should note that the NEAS Center, we're partnering with the Mercatus Center and looking at their state reg data, specifically on occupational licensing. So on our website, we have the specific restrictions, so like how much the fees are, what the required education is, things like that. We're also using reg data as a tool to see just how difficult is it for people to read through these codes, to understand what's going on, how complicated is it written, which I think is going to be a great addition to what we do. Whitney, you're no stranger to most of the people in the room. You've worn several different hats in the Mississippi government, working in different areas. So you've worked with Governor Phil Bryant in his office, and now you're serving as Deputy Attorney General. So in one position, you're working with the creation of policies, and now you're focusing on implementing those policies in your new role. Can you describe some of those efforts you've been involved with?
Yes, thank you, Connor. And let me just say what an honor it is to be on the stage with you and James. And thank you to Empower for putting on this important event so we can discuss these issues and how we move Mississippi forward. I became interested in occupational licensing in 2016. I joined Governor Phil Bryant's staff then, and I've been fortunate to work for elected officials, both Governor Bryant and Attorney General Lynn Fitch, who are equally as interested in occupational licensing and regulatory reform and have been leaders in this space. When I joined Governor Bryant's staff, one of the things that I oversaw was the gubernatorial appointment process. The governor has appointments to hundreds of boards. It is a very intense and detail-oriented process. But one thing I started to realize is just how large of an impact that these occupational licensing boards have on our state, on individuals who are looking to move here, who are looking to practice in a certain profession. And an issue that came up that year was how to address a recent Supreme Court case. That was the North Carolina Dental Examiners versus FTC. It was a United States Supreme Court case in which the court held that state boards, state occupational licensing boards that were controlled by a majority of active market participants, in that case it was a dental board controlled by a majority of dentists, do not enjoy state action immunity from antitrust claims if there's no active supervision. So we started to talk about, under Governor Bryant's leadership, how to kind of remedy that problem, but also how to adopt some good state policies. Policies that would encourage job growth, policies that would encourage smart regulations that help people go to work quickly and easily. And the result of that was a piece of legislation in 2017 that created the Occupational Licensing Review Commission. Some of you in here may be familiar with it. For those that aren't, I'll give you some details behind that. This commission is made up of the governor, the secretary of state, and the attorney general. The commission was originally charged with reviewing all prospective regulations that occupational licensing boards promulgate, and in particular those boards that are controlled by active market participants. In Mississippi, we have 29 of those boards. They have to submit their regulations to the Occupational Licensing Review Commission for approval. And what the commission does is they ensure that that regulation complies with the state policy. Part of that legislation, we adopted a state policy that articulated that it was the policy of the state to favor the least restrictive means necessary that still protects the health and safety of the public, but also regulations that encourage economic growth, regulations that encourage competition, job growth, innovation. So that was very critical, and it was that piece of legislation I think was landmark. We were far ahead of most states in creating a commission like that or a mechanism like that, and thanks to the legislative leadership, Speaker Gunn at the time, Governor Reeves, Lieutenant Governor Reeves, and in fact the author of that bill was our own Judge Corey Wilson, who now sits on the Fifth Circuit. So the commission created in 2017, it has been, I think, a successful model. They have, since 2017, they've reviewed hundreds of regulations. We've seen a successful transition of power from one group of commissioners to another. It's proved to be a sustainable model. And some of the, I think, the positive and kind of wins we've seen from the commission, number one, I think the commission works with these boards. When they come before the commission to present a regulation, they work together the commission understands the boards have a specific goal to achieve, and they want to protect the profession But the commission kind of serves as a check on that. And I've seen instances where the commission works with these boards to craft a regulation that is less restrictive and that serves the community and serves those individuals better who are trying to obtain a license. Another win we've seen with the Occupational Licensing Review Commission, or OLRC for short, is boards coming before the commission who present regulations, and they're proud to admit that this is a less restrictive regulation. We're rolling back some of our restrictions here. We're changing this. We're making it easier for someone to obtain a license, making it easier for someone to maintain a license. We're reducing fees. So we're seeing a lot of boards that are proud to make those changes and proud to present those to the commission. And we're also seeing, and maybe this is something that's been unsaid, what we're not seeing is some regulations. I think there are a lot of boards who, before they enact a new regulation, I think they think about the OLRC, and they know that there is a check on that new regulation, that they're going to have to answer some difficult questions. Is this the least restrictive regulation we could put in place? Does this encourage job growth? Does this encourage innovation? And so they think twice, and maybe that regulation wasn't necessary. So I do think there are plenty of those regulations that the commission doesn't see, and I think that's, quite frankly, that's a win for Mississippi. So I've been proud to be a part of that commission in working with Governor Bryant to help establish the commission. And since coming on board with General Fitch, and she is now a member of the commission, she kind of took a fresh look at it and said, this is a great tool for the state. How can we go a step farther? And she wanted to pursue some legislation that gave the commission the authority to look back at existing regulations. As the legislation stood in 2017, they could only look at prospective regulations. Those are new regulations that were promulgated. But she wanted to look at the regulations that were already on the books, and ensure that they also comply with the state policy. And so again, working with our legislative leadership, Speaker Gunn, and this time Lieutenant Governor Hoseman, who actually was a former member of the OLRC, we were able to pass some legislation that gives them the authority to look at regulations that are already on the books and ensure that they are the least restrictive means necessary. They encourage job growth and economic progress, and the commission can actually work with the boards to either to ask them to withdraw that regulation or to amend it to comply with the state policy. And I think that's a really important tool. And as our professions change, and as we've seen over the past year and a half, how quickly they can change and how quickly we have to be able to adapt to what's going on. So I've been very proud to work with both the governor and the attorney general on these measures. Another thing that I worked with Governor Bryant on is changing the licensing for military spouses. I know, Conor, you mentioned that example of your friend that's in the military. And as a military spouse myself, I'm very sympathetic to this issue. But it's an issue that really is a problem for our military community. When these families move, the spouse usually, if a spouse holds a license in a particular area, it's very difficult for them to obtain that license in the new state. And a lot of times they're moving for just a short period of time, maybe a year or 2 or 3, and sometimes it's too restrictive for them to get a license to justify paying all that money, or spending 8 months to get a license to only be able to practice for a year and a half. So Mississippi actually was on the forefront of this issue, and they passed legislation in, I believe, 2013. The problem with the legislation is that it just didn't go far enough, and some of the boards really didn't know how to interpret it and apply it. And so after some discussions with individuals, military spouses around the state, and some discussions with the Department of Labor in 2019, one of the things that we pursued is a change to that legislation, forcing them, or rather requiring them, to issue the license promptly, or issue them, I think it was in 4 months, if the spouse and the family member, the military member, was in the state for 3 years or less. So that was an incremental change, and since 2019, the legislature actually went a step further in 2020 and amended that legislation, and now requires these occupational licensing boards to issue licenses to not only military spouses promptly, immediately, whether their military member is in the state for 3 years or not, but also extended it to military members who have that specialized training that you were mentioning. If they've received the training in a particular area, we are now requiring them to give a reciprocal license here, which I think is very important. Mississippi is a state that is very supportive of our military. We have a really great military community, and so it speaks very highly that we continue to push these efforts forward to provide these are quality of life issues for them. So I've been very excited to be a part of that, and one of the things I do in the Attorney General's office, or rather some of the people I work with, we actually have attorneys that advise a lot of these occupational licensing boards. And so we help them understand these new legislative changes and these new laws and how to implement them at the board level. And I think that's critical because these board members, they're part-time, they have full-time jobs, and they come to a board meeting maybe once a month, maybe once every other month, and some maybe twice a year. And so we have to, our counsel, our legal counsel is a key person for them. They have to be able to tell them, here's what you need to be doing. So we've really undertaken an effort to educate the attorneys in our office who advise these boards on the new legislative changes and how to advise their boards so that they can implement these new policies as quickly as possible. So that's just a few of the things.
Yeah, only a few.
That the state's been doing. So
Yeah, that's awesome. And we can understand like why regulatory reform is difficult in theory, but you were actually there like in the trenches. So do you have any? Can you share some of the challenges that you experienced and what you did to overcome to like get these reforms passed?
Absolutely. I think when we first started talking about occupational licensing reform in 2017, it was definitely a new topic, and I think there was a lot of concern on behalf of the boards and the particular industries that this commission would usurp the specialized knowledge of these board members, and I think we've seen that that's not what the commission does. I mentioned this earlier, but they serve as kind of a partner with the board to help create better regulations, but they're not second guessing the judgment of a doctor for a medical licensure board or the dentist for a dental board. I think another thing that was a concern at the time was that this board would serve as kind of an obstructionist, and they would veto regulations left and right, and that hasn't happened. Again, it has been a real partnership that the Occupational Licensing Review Commission has formed with these boards. They want the boards to be successful. They want the boards to operate efficiently and effectively. They don't want to be a hindrance in the process. So rather than striking the regulations down, a lot of times they will make amendments. They'll work with them to find the best solution for the state possible. I think another thing we learned in passing that legislation when I was working for Governor Bryant and we first kind of came up with some language, it gave the governor the authority to review all the regulations. It actually wasn't a commission model. And after going through the legislative process, they actually made the decision to create the commission, which I think was a great idea. I think you need that collective knowledge from the governor, who's the chief executive, the secretary of state, who is responsible for business registration and our administrative procedures, and the attorney general, who's the chief legal officer. I think that collective knowledge really contributes well to the commission and serves the state better. So we've learned through that process, again, partnerships. It's partnerships and collaboration. We can, I think, achieve the best result for the state.
All right. James, Whitney hit on some of her experience trying to move regulatory reform under the previous governor. I think now would be a good time to talk about why we need to think about reform in the first place. So what's the problem that we're trying to address with this regulatory accumulation, and how did it get to be a problem?
Sure. I think you can think of the problem we're addressing as coming in two forms. One relates to the process whereby regulations get made, and the other aspect is in terms of what are the effects of all these regulations. So in terms of process, over the last 75 years, the federal government and all of the states have passed Administrative Procedure Acts that lay out a process for creating new regulations. Those procedures are fairly detailed in most cases and allow public input and economic analysis in some cases. But this is all before regulations get put into place. So it's all kind of perspective or speculative about what the effects of regulations might be once they're actually enacted, once they're on the books. And most states are put much less emphasis on reviewing regulations. It's not really as much of a responsibility for anyone to go back and see whether the regulation actually had the effects that were expected. And in many ways, that's why the kind of commission we're talking about is an innovation, because it actually tasks somebody with saying, hey, are these regulations working or not, and should they be amended? It gives a permanent entity that responsibility, which is actually somewhat rare. It may sound crazy to hear that, but it's actually looking back at regulations to determine whether they're working or not and giving them a careful look does not actually happen that often. And even the business community is often not that thrilled about going back and looking at regulations that maybe they already expended resources to comply with. And that regulation may now be acting as a barrier to new businesses that want to come in and enter their industry and compete with them. So the business community is often very vocal about new regulations that are coming down that could impact them, but isn't always as on board with reviewing regulations. And so that's why it's important to create institutions that have this responsibility and take it seriously. Because for whatever reason, as we set up procedures for regulations over the last 75 years or so, this review component has tended to get overlooked. So that's the procedural problem that I think we're trying to address, which is look back or review of existing regulations to figure out what works and what doesn't. So then there's what is the effect of all this regulation? So one of the main problems that we see, and this is really across governments at all levels, state, local, different countries, is this issue of regulatory accumulation. So this is the idea that each year new rules get written, they get added to the books. Maybe some old rules get amended or removed, but not so many in most cases. And so there's this natural tendency for the amount of law that exists to grow, and for the legal environment to grow ever more complicated. And increasingly, the academic evidence is showing that the accumulation of regulations over time is a drag on the economy, it's a drag on economic growth. There's an economist at the Progressive Policy Institute in Washington, his name's Michael Mandel, and he likes to compare the effect of regulations to dropping pebbles in a stream, and I really like this metaphor. So you drop one pebble, there's no effect. The water just flows as it was before. You drop 1,000 pebbles, the flow starts to slow. 100,000 pebbles, now maybe you've blocked the stream. And that's the case even though that last pebble was also insignificant. And if you just look at that last pebble, you'd say, well, this isn't a big deal. Why can't we do this one? But you would have said the same thing about the one before, and the one before, and the one before. And before you know it, you've ground the economy to a halt. So that's kind of the macro level problem, and is that economic growth and activity slows. Some colleagues of mine at the Mercatus Center have estimated that federal regulation is slowing national economic growth by about 1 percentage point a year. That may not sound like a lot, but it means that if you had put in place a cap on the level of regulation in say, 1980, and that doesn't mean no new regulations, it just says maybe for every rule we add, we're going to take one off the books just so the level stays the same. So we get kind of a constant number of rules. Well, then by 2012, we've estimated that the economy would be about 25% larger, which is about $4 trillion or $13,000 per person in the United States. So because of this drag on growth, you get this compounding effect. And over time, over a couple of decades, really not that long, this can actually have a pretty major impact on living standards. And you can think about all the things that $13,000 per person would go towards. So I see the main issues as one, process, putting in place better procedures for reviewing rules, and also that will teach us something about how to better design rules going forward. And two, this issue of regulatory accumulation and slower growth.
Thanks. Whitney, I know you talked about your role with the creation of the Occupational Licensing Review Commission and your current role in executing that policy. But the Mississippi legislature had a busy couple years when it comes to regulatory reforms since you left the governor's mansion. So you can talk a little bit about some of those bills we've seen come out of the legislature. I know you mentioned some already.
Sure. Well, first of all, I think what we're seeing is a real movement, and I think we have elected leaders and legislative members who are excited and who are trying to move the needle forward and make it easier for people in Mississippi to go to work, and quite frankly, easier for people to move to Mississippi and go to work, which is great. I think since 2017, when the Occupational Licensing Review Commission was created by the legislature, they have each year passed at least one bill that has been aimed at addressing regulatory reform as it relates to occupational licensing. Some of the things that we have seen, I'll just start off with the big one this year, is universal licensing recognition. So if you move to Mississippi and you hold a license from another state for a number of professions, I won't go through the list, but it is a long list, you get and you meet certain qualifications. If you are licensed in a similar fashion in the other state, you can get automatic reciprocity here in Mississippi. We're the first in the South to pass that type of legislation. It's extremely important, especially in a year like this year and last year, where people are saying, I want to be in a state where I have the most freedom. I want to be in a state where my kids can go to school during COVID. And so we have, I hope that it has contributed to individuals moving to Mississippi, and I hope that it continues to contribute to that. One thing I mentioned earlier, and I think need to kind of touch on again, because just what you were saying, is legislation in 2020 that gave the Occupational Licensing Review Commission the authority to look at regulations already on the books. General Fitch, as the former head of the Mississippi Department of Employment Security, knows how important it is for people to obtain a job. And that is going back in the books and looking at those regulations that have been there for years and decades, and it's something that, quite frankly, these boards may not have had time or the resources to do, but it's something that needs to be done. And it also gives a voice to those licensees who are licensed by the board. If there's a regulation that's negatively affecting them that can be either repealed or tweaked to be less restrictive, this is a perfect avenue. They can come to the OLRC, they can present that regulation, and OLRC can consider a way to address it. Another thing that we've seen, and I think you heard mentioned on the last panel, is the Fresh Start Act. And that was a piece of legislation that prohibited occupational licensing boards from passing regulations that prohibited somebody from obtaining a license because they didn't have good moral character or because they had any criminal conviction. The criminal conviction has to be directly related to the duties of that board. So it definitely opens up the scope there and allows people that may not have been previously eligible for those licenses to obtain one and to go to work and be a productive member of society. And so I think that's been an important one. And then another one that passed this past year that I'm particularly proud of because our office played a role in is some reforms to the cosmetology licensing statute. Before, the statute required licensing of eyebrow threaders, makeup artists, and those individuals who put eyelash extensions on. I know some of you in the audience may be familiar with those, may be customers, but there was a requirement for them to obtain a license from the Cosmetology Board, which entailed hundreds of hours of training. And unfortunately, the training they received didn't directly train them on that particular area of practice. And so the state was actually sued by an eyebrow threader, and they made a 14th Amendment constitutional challenge to that statute. And as the Attorney General's office, we are charged with defending the constitutionality of our statutes. But in that particular instance, what made the most sense for Mississippi, for customers, for the individuals practicing in this profession was to find a creative solution. And our attorneys who were working on that case worked directly with legislators to craft a piece of legislation that addressed the lawsuit, addressed the problem in the law, and quite frankly, freed these individuals from licensing burdens. So I'm very proud of that and the work that we did. So it shows that we can find creative solutions and we can unleash some of these, to use the term of the day, unleash some of these licensing restrictions for the betterment of Mississippi.
All right, thank you. And since you brought up occupational licensing, I think it's a great time for me to get to talk about it. Occupational licensing laws, we can think of them as a permission slip from the government that people need before they can go work in a profession. So state legislatures pass these laws and basically require people to get the license. They cannot practice without it. They also set the requirements. So these are things like education, the required education before you can get into the field, the training they have to undergo on top of that education, the exams you have to take, both sometimes they're national exams that people across the country have to take, sometimes they're state specific to the individual laws within that state. They have to pay fees, and there's other provisions like good moral character clauses, minimum ages, language proficiencies, things like that. The purpose of all these restrictions before you can even enter the field is to ensure that there's high-quality professionals within that field providing services to consumers. A lot of times these are fields, or at least initially they were fields, where consumers face the potential for serious harm from low-quality services. It's not just like if I purchase a bad shirt and wore, maybe it'd be a little bit embarrassing being up here, but something where you could actually get physical harm. Typically, the market will filter out the poor performers, and over time, you don't have to worry about the low-quality professionals staying in the field. But when you have a case where people can get seriously hurt, a lot of people are going to get hurt before that person gets forced out of the profession. So they responded by creating these barriers before you can get in. Demonstrate your competency and show that you have the skills necessary. It makes consumers more likely to purchase these services because they can be more comfortable that the person they're going to has these credentials. They know they're well-trained enough to enter the field and be given a license. And they don't have to worry about the harm that'd be associated with the poor services. Now, this makes a lot of sense for occupations like healthcare, but licensing has grown far beyond healthcare and the initial professions that were licensed. In 1950, only 5% of the labor force needed a license to be able to do their job. Today, that number is around 25%. So licenses were once reserved for skilled professions where low-quality services posed a serious threat to consumers. So like physicians, lawyers, dentists. And these are professions we typically think of when we think of licensed professionals. But there's a lot of professions, especially ones that don't require a college degree, that now require a license that didn't in the past. So for example, from 1993 to 2012, the state of Mississippi added licensing requirements for 49 professions that don't require a traditional four-year college degree. So these are the types of professions that offer a path to the middle class and a path for entrepreneurship for people that don't have the traditional college degree. These professions include massage therapists, childcare workers, manicurists, general handyman services, licensed landscape workers. So it's difficult for people to try to enter these professions. Typically, if you don't have a college degree, like I said, you can enter these professions fairly simply and begin practicing and begin making money. With licensing requirements, you have to take time off to be able to do that. You have to undergo a certain amount of training and education before you can get in. So not only you're not making money during that time that you're training, you're also paying for the education itself. It may sound like this shouldn't be too much of a problem, but it turns out that this does have a significant effect. Economists estimate that the number of workers in profession is reduced by between 17 and 27% when the profession is licensed. So this is a lot of people that are being locked out of the labor market because of these barriers to entry. Sometimes they end up being unemployed, not being able to find a job that meets their skills and their interests. Other times they're forced to work in other professions with lower pay than they would have in that licensed profession. I'll just touch on criminal justice, even though we just had a whole panel on that. Licensing has been found to increase the recidivism rate because of the good moral character provisions, where people need to demonstrate that, basically meet a very broad set of requirements. One of those is usually not being involved with the criminal justice system. So people coming out of prison, trying to reestablish their lives, are locked out of a large number of professions. Trying to find the number here, I'm sorry. Licensing increases the recidivism rate when you have these good moral character provisions by 9%, research has found. Now, it does increase the wages that professionals practicing in the field are forced or are able to make, but that's not because they're providing better services to consumers. Consumers are being forced to pay these higher prices because we have the supply limited in the field, because we have people that the market would be willing to have these people enter the profession. There are plenty of consumers willing to pay for the services from them, but they're not able to because of these licensing requirements that's keeping them out. And these increased wages pass on to consumers in the form of higher costs. So licensed professions, based on the services they give, the prices are increased for consumers by between 3 and 16%. Now, there's been a lot of reforms recently. It started to pick up a lot of steam with the Obama administration's 2015 report on occupational licensing. And they were giving, through the Department of Labor, grants to individual states to look through their occupational licensing, compare them to other states, and see what they could do to make it easier for people to get to work. The Trump administration continued this emphasis on occupational licensing reform. And when we look at occupational licensing reform at the state level, both Republican-led states and Democrat-led states were enacting reforms, and very similar types of reforms, trying to make it easier for people to find jobs. I won't touch on some of the things like universal recognition or the occupational licensing review that Mississippi's been doing, but there are a few other types of reforms that we see other states enacting. One is a criminal justice reform, so specifically getting rid of these good moral character provisions, or requiring that states only, or the state licensing boards only look at criminal history that is directly related to the field that they're applying to. So they're not being locked out of the job for something totally unrelated to the services they're going to be providing. Another is reducing specific barriers. I know Mississippi had a bill this year trying to reduce barriers in a few professions. Some states have found success with that, delicensing occupations that don't have education requirements, that are just throwing up fees and preventing people from getting the profession without giving consumers any attempt at trying to demonstrate a higher quality. And finally, a few states like Alabama, North Carolina, and Vermont have been experimenting with apprenticeships and allowing people to, rather than forcing them to take time off of work and paying to go through education, giving them an alternate pathway where they can work as an apprentice, they can learn from a licensed professional, and they can earn some money while they're doing it. So over time, they do demonstrate their skills, but at the same time, they're not being forced out of the labor market for it. So it makes it a lot easier for people, whether they come from a low-income background and they just don't have the money to be able to take time off for education, or whether they're switching careers midway through their career. Now, James, since I've been talking about occupational licensing, we're now on the topic. I'd like to get your take on an intersection of sorts between occupational licensing and healthcare. Typically, when we think of healthcare and healthcare reform, the focus is on who's going to pay for the health insurance. But healthcare is deeply regulated from a lot of different angles. So this has an effect on cost and access to care, a lot of other things besides just who pays for it. We talked a bit about full practice authority, but that's a smaller piece of a much larger picture. So do you have a perspective on how regulation impacts the provision of care? And how do you think about balancing safety concerns with patients' access to healthcare?
Sure. So those are tough questions. I would say, first of all, what is a regulation doing? It's restricting behavior in some way. And a licensing regulation is restricting who can enter a certain profession. So by nature, these regulations are reducing the supply of healthcare professionals when they are healthcare regulations. Now, that can very well be a good thing. It could be that we're eliminating the lower quality workers from the profession, and therefore we're only left with the very highly qualified workers left. That over time, however, as a result of restricting entry into a profession, sometimes quality of the profession will erode as a result of a lack of competitive pressures. And so when you look at the research into the effects of licensing regulation on quality of service, it tends to be kind of a mixed bag. Some studies find some improvements, some studies find quality gets worse, some studies find not so much of an effect. And so this could be a result of these kind of dual forces. One, we're taking away low quality workers, which raises quality, but two, we might be slowing dynamism or innovation by reducing competition, and that lowers quality. The results are more ambiguous in terms of what happens with the wages of people in the licensed professions, which is their wages go up. And that's good if you work in that profession and you can obtain a license. It's not so good if you're a customer. On the other hand, if you're a customer and the quality improves, it might be worth it to you to pay a little more for higher quality. But if quality doesn't improve, then you're just left bearing a higher cost. So this is kind of the dynamics of, I suppose, of how licensing regulations affect the quality of care. I think it's telling that during the pandemic, we've seen most of the action in this area go in one direction, which is to reduce restrictions in order to increase the supply of care. So we've seen states accept licenses from other states. We've seen regulations known as certificate of need laws, where you have to go to the government and get permission to provide a new service, or even do something like provide more hospital beds in your hospital. So these kinds of regulations have been waived or rolled back. I've done some work on pharmacy regulation. We've seen waivers so that pharmacists can provide vaccines, or so that they can test for COVID or other ailments. Most of these sorts of activities were prohibited. In some states allow a little bit of it, but there were national waivers to allow pharmacists to engage in these kinds of activities. And so I think it's an important question now. Did these restrictions make sense to begin with? There should be ideally some kind of review of these rules at a minimum, I would think, to assess whether it makes sense to bring them back or to maybe amend them permanently or waive them permanently. In the space of pharmacy regulation, one area where I think there's potential for increased care is in terms of pharmacist prescribing authority. So most people don't realize this, but you need a doctoral degree to become a pharmacist. So most states require you to have a doctor of pharmacy degree, 6-7 years of education. These are highly trained medical professionals that in some cases have more knowledge about medications than some physicians do. And yet they're severely restricted from refilling a prescription even, or making a minor change to a prescription. In Idaho, Idaho probably has the most liberal prescribing regime for pharmacists, and pharmacists there are allowed to test for a variety of different minor medical ailments like flu or strep throat. They can prescribe based on the results of those tests, and they can prescribe medications for minor ailments. They're not prescribing opioids, but for minor medical conditions, a pharmacist can prescribe you a medication. And so I think that all of these restrictions taken together restrict healthcare provision. And at a time when costs are rising, but there's budgetary pressure, we have an aging population, we should be thinking about ways to increase the supply of healthcare and not just subsidize demand for healthcare.
Well, thank you. To close, the bill for regulations can have a substantial impact, but as we've seen up here, despite that, Mississippi has been taking great strides trying to reduce that and make people's lives better.